I think Harry's initial comments on, what's the big deal about innovation is a nice segue of first remembering why we're so focused on innovation. Harry said there was another session on necessities, for example, and it sounded like it was quite fundamental. Should we really devote time and energy in the matter of innovation? Obviously, these are questions designed to have us contribute into the matter from this perspective. And one thing I would want to say, for the benefit of the audience and not for Harry's benefit, who is very well versed in this anyway, is that there's nothing that innovation doesn't get into anymore. So necessities is a matter of innovation as well. Human progress, hunger, the fight with child labor, human rights, anything has to do with innovation. Climate change has to do with innovation. Basically, anything that touches welfare, the welfare function of human beings, has to do with innovation. And that's fine and dandy, but now I'm going to steal a line from Fred and say there's a good news and a bad news. The good news, we know that innovation is valuable, and we try to cherish it and we try to protect it through competition law. But the bad news is it doesn't seem that we know exactly what we're doing. So there's a lot that's going on under the banner of protecting innovation, and that might be perverse. We understand the concept of dynamic efficiencies, how important it is, and the economic efficiency is not only dedicated to cost efficiencies or allocative efficiencies, dynamic efficiencies being even a bigger chunk of welfare maximization, perhaps. These we understand, but then again, on the basis of a specific file, you cannot find two economists agreeing on what exactly is going on and how to attain dynamic efficiencies. So on to the 35% then in the voting at the beginning, which Harry found interesting, and I also found interesting, because the predisposition of the participants would be expected to be that they care about innovation, and they're coming from predominantly the developing part of the world. So at 35% saying we should butt out, or emerging markets should butt out, is interesting. Interesting but understandable. I think the idea there is that the jurisdictions that are the developing countries are not the originating jurisdictions of innovation. Innovation rarely comes out of those jurisdictions. So the fear is that these jurisdictions are going to be interfering with something that is happening elsewhere in the world without knowing exactly the dynamics and the ecosystem effects and everything. Maybe that may have led to the 35% saying no. Another reason why it may have happened is people may think, and I would partly agree actually, that the developing countries' competition authorities are more prone to subscribing to protectionism under the banner of protection of innovation. So basically, as the concept gets softer, as the direction of enforcement gets flu, there is ample opportunity for competition authorities to pursue other policy objectives and call it protection of innovation. So that might be a risk for the developing countries. Another issue, obviously, is that the economic analysis capability of the competition authorities of most of the developing countries are not as high as the economic analysis capabilities of the competition agencies of the developed markets, which in turn means that there might be more room for scaremongering under the banner, again, of protection of innovation. So this will happen, that will happen. Here is what terrible things will happen to innovation. A lot of narratives, but not enough quantifiable data or analysis. Query whether even the developed part of the world can do that analysis properly. But most competition agencies in the developing countries do not have as deep a pocket and as big an economic analysis unit. So that might also have led to the 35% saying perhaps the agencies of the developing economies should stay at the sidelines on this one, on the matter of protection of innovation. Now, yet, if I were to turn my attention to the 65%, I would assume that some of that must be constituting from people who say innovation comes in different forms. It can be frontier innovation, groundbreaking innovation, as it so frequently is in the developed part of the world, or it can be copycat innovation, which would actually mean that the welfare function of developing countries that subscribe to the copycat innovation would over time be closer to the more developed sides of the world. And I'm not going into an IP debate here. I'm talking about copycat innovation in terms of, innovation that draws on the achievements of another source, but lawfully expanding it and building on it, basically. But it's still copycat ultimately. Or expired patents and what have you. Even that kind of work requires a little bit of innovation with the available resources of the developing countries. So it's not the same innovation because your input blend is different in developing countries, and that there may be welfare hidden in there, and the competition agencies of developing countries may want to protect the copycat innovation. And there is also one danger that I would want to flag at this stage, which is that if the agencies of the developing countries were to be a little too bullish, a little too aggressive in protecting innovation, and if they were to then take the flag bearer role, so it's not the FTCs and the Department of Justice and the CMAs and the European Commissions of the world enforcing predominantly, but rather some agencies of the developing world have taken such a leap forward that they are breaking new ground on a global scale in enforcement, then obviously they may come across situations where some of these companies are withdrawing their products from those particular jurisdictions. And that may also become an issue of feasibility of engineering, interferences with the products, not wanting to inspire the agencies of other countries to come up with those kinds of enforcements and all that. So that may be a reason why the developing countries might want to at least calibrate their moves with what's happening elsewhere in the world. And last words on the matter in my first intervention is that I think it's also interesting to think about evidence issues in the developing countries, because one issue that most of the agencies in the developing countries will run into will be that they will have to rely on a lot of presumptions, as most of the evidence relating to these matters will be in the developed countries. The correspondences, the intercompany correspondences that relate to innovation effects of a certain move and all that. The subsidiaries in the developing countries will not have these original conversations and correspondences. They will just be subject to certain indicia or certain reflections of a decision that is taken already outside of that country. So it's going to be a difficult ball game for the agencies doing work in enforcement in the innovation sphere in the developing markets, in my view. I think the interesting discussion to get into is also whether the developing countries might be risking losing their competition law policies, the purity of their competition law policies, while trying to enforce in the innovation sphere. That's also a danger that we should highlight. When we go to the swivel example of the authority saying Uber will not sell below a certain price, for example. If this was a pure predatory pricing case, where Uber was selling below average variable costs, then I have nothing to say. But then again, we wouldn't highlight this as an innovation case. If it was not the case, and if the goal of the agency in Egypt was to provide margin for the local entity, then I don't know how we can profile it as an innovation case just because the local entity happened to be on NASDAQ and all that. The results are satisfying from a national perspective, I understand that, but you're also risking losing the very pure goal of competition law, or are you losing it, while trying to run after some type of protectionism and calling it innovation. I'm not saying that's what Mahmoud Momtaz was doing. It's good intellectual discussion. I don't even know the facts of the case, so this is not a critique of that case specifically, but I'm trying to make a point that it's quite easy for the competition agencies of developing countries to lose their way while being a bit too starry-eyed with trying to enforce in fostering innovation. The same kind of feeling I got with the J&J example as well, a case of portraying patent extension as an exclusionary abuse. I'm not saying it's an impossible case, but I am saying that it's a very borderline kind of a case. So when the company takes a step back and people benefit from it from a healthcare perspective, it doesn't automatically translate that because the results were rosy, competition law has done its job. The competition law may have still been hijacked in the process of following the innovation goal, or what was thought to be the innovation goal, and it may have served to an unpredictable environment in competition law and all that. Why am I getting into this debate? Basically, I'm trying to make a point that there are dangers for developing countries' competition agencies. The more they focus on fluid concepts like innovation, the more room there will be for pure competition law cases becoming more and more unpredictable. And one has to be quite careful in making sure that there is an understandable competition policy preference of the authority, that the subjects of the competition law understand what the outcomes of certain acts are going to be, and there isn't a mystical phenomena of innovation enforcement that is from time to time hitting certain files and then is disappearing. That's all I'm trying to say. So, I mean, it goes back to the discussion of, whether there's a pure competition law or not, a little bit. But I think we may have fudged it a little bit between two concepts. The static versus dynamic approach is obviously something that needs to be discussed, and Fred, in usual manner, so clearly explained what it is. And I think, yes, the static approach is not helpful, so there will have to be a more holistic and dynamic approach to competition law enforcement matters. But the pure competition law enforcement is not basically an ode to something that is so successfully being done in the US or elsewhere. It's basically only a reference point about any competition law regime that tries to focus on being a tool of free market economy. Any competition law regime that is trying to first and foremost target economic efficiency. That's what's pure about it. But obviously, then you can have add-on policy prerogatives and all that. So long as you know for a fact that you're making a preference, I think those tweaks can happen, and in developing economies, they will happen even more. So protection of small enterprises to the extent has to be a goal for developing competition agencies, so long as they understand that that's what they're doing on that particular given file, and this may not be serving the midterm economic efficiency goals, but they're hoping for something else to happen. That's all fine and dandy. It's not, we're not in a position to discuss that bit of the thing. My problem with the innovation goal being integrated without adequate tools is, and I am belonging to the 65%, by the way. So I think emerging market economies should definitely have competition agencies that are enforcing in favor of innovation. If not for any other reason, for the reason that James Hodge so correctly said, which is that the global companies are not using the same policies everywhere in the world. So you may need to nudge them. But in any case, I think my last sentence on this topic is that the fear with the innovation part of things is that that goal in and of itself is so incalculable and difficult to follow and mystical and fluid that competition agencies may lose their own bearings in trying to enforce in favor of innovation, and they may not be in charge of the situation the way they are in charge of the situation when they say, on this file, I'm going to protect the small enterprise for the sake of it being small. It's not going to be that clear in the innovation enforcement sphere, is my fear.